Our last case for the morning is McDuffie versus Neal. Give everybody a minute to reset. Good morning. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive. Mr. Marco, you can reserve time for rebuttal, but we ask that you keep track of that yourself, and you may begin whenever you're ready.
Thank you. Good morning. May it please the court, John Marco on behalf of the estate of McDuffie-Connor. I'll reserve 3 minutes for rebuttal. I'd start with the introduction of Judge Hood, who wrote the dissenting opinion in this case, where he said, "This is a case with messy facts for both sides that require a jury to sort it out." And I urge this court to adopt the reasoning and rationale of Judge Hood in his dissenting opinion and reverse the majority and send it back for a trial, a jury trial, so the jury can sort out the messy facts in this case. The Court of Appeals majority is somewhat perplexing in that they ignored the positive evidence for the plaintiff and the plaintiff's case. Specifically, for example, they said the turn signal, there's no evidence that the turn signal was malfunctioned before the crash. That's just not true. There was 3 experts' opinions, including a Michigan State trooper who performed a traffic inspection on the vehicle, who's not our expert, who was hired by the state of Michigan and has been doing it for over 10 years. That's one example. The second problem with the Court of Appeals majority is they made credibility determinations in this case. They said, we're going to believe these witnesses over these witnesses, and they took the positive evidence and they cherry-picked evidence from particulars. For example, the defendant truck driver. The Court of Appeals majority picked out portions of the truck driver's testimony that they liked, and they ignored portions that they didn't like. For example, him saying, I can't explain why I turned directly into a car on the side of me without looking, because I should have seen it if I had been looking at my mirrors. That's the second problem. And the third problem with the Court of Appeals majority is they excused the destruction of relevant evidence that the defendant was required to keep under both common law and federal regulations. And they said that that was okay, and then they used that, our lack of that evidence as a basis for reversing the trial court. So you don't get to destroy, it's essentially rewarding the destruction of evidence from the defendant company in this case. There was a robust record. There was a lot of discovery in this case. The evidence below that we produced on July 17, 2019, Mr. McDuffie was in a parking lane on Myers Road in Detroit. It's an industrial area. There's a lot of pedestrians. There's bike riders in this area. He got into his vehicle. It's on video, as you saw from that we produced and we produced below. And he's tried to merge into the main travel lane of the road. He was not allowed in by the dump truck and by Mr. Pace, who was a witness in this case. And the dump truck took a right-hand turn directly into him and killed him. We produced significant evidence to go to the jury in this case. First of all, we produced evidence that the driver of this dump truck was not qualified and should not have been driving a 70,000-pound dump truck. He had 38 traffic violations. This guy was not fit to be driving a pedestrian vehicle, let alone a 70,000-pound dump truck. He had been dishonorably discharged from the military. He had substance abuse issues. He was not able to follow rules. He had been fired from every single trucking job that we were able to find that he worked at, including one, Haggerty Logistics, where he was fired when he crashed a semi-trailer into 2 different pedestrians within 5 hours apart. The reason that he was hired for this job is because the defendant company was being sued by the union who had provided it with drivers because it had failed to pay them and they owed unpaid wages. The area in this case, so we produced the video, which we then produced deposition testimony and the report of a Michigan State police officer who investigated this directly after the crash. That's his job. He's been doing it for over 10 years. He's investigated hundreds of commercial vehicle crashes who found, number one, there was a broken turn signal on this truck that was broken before the crash. And how do we know that? Because the area of the crash, and the Court of Appeals just ignored all this testimony, the majority did. And I don't know why, and I don't know how, because we briefed it and I argued it at oral argument. But the wiring on this particular 70,000-pound dump truck, the wiring for the rear turn signals is contained in the upper part of the hood, okay? The upper part of the hood was not damaged in any way in this crash. There was no damage to it, it was not shaken up, there was nothing. The wiring was intact, but it was shorted out, which means when the defendant driver pushed on his brakes, if he did, their turn signals are not gonna blink. They're gonna turn solid red. And every driver here knows, and everyone who drove here to this courthouse this morning knows, solid red means somebody's braking and they're stopping. So to anyone behind the truck, it would have looked like the truck driver was braking, which in this case, if you look at the video, because my client's dead and he wasn't able to offer any testimony, a braking vehicle would have signaled to the driver, Mr. McDuffie, that he could pass the truck that he had been trying to do.
So I know that both you and brother counsel are focused on whether, whether everything was working properly,
Yes.
in addition to everything else. But can you talk to us about duty and whether there was a breach of the duty here to ensure the turn was clear before turning?
Yeah, and we produced statutory violations which establish per se negligence, at least allows a jury, unless they have an excuse, which is MCL 257.648, which you must determine that when you're making a turn that it's safe to do so and there's no one in the way. This protects motorists, it protects children.
That's the duty. Talk to me about the breach of that duty.
Yeah, so he did not follow his requirement under the statute in making a safe turn, and there's all kinds of cases going back 50 years that talk about this. Estate of James Thomas Bush, Amick versus Baller, Fanari versus Gregory Lee, which we cited all these cases. You have to make sure that when you turn, that the lane is clear. That's why they have side mirrors. That's why the training requires the mirrors to be adjusted in a pre-trip inspection to make sure that the lane is clear. This protects motorists. This protects children and pedestrians. This protects bicyclists. I don't know if anybody here bikes, but I do sometimes to work when I don't have to wear a suit. And there's bicyclists that go in the lane, and you have to make sure can get harrowing, because if a vehicle is not paying attention pursuant to their statutory and common law duty, you can get hit and you can get killed, such as happened in this case. Secondly, he didn't look at his mirrors. So the defendant driver can't explain why he didn't see the vehicle. In fact, he testified, even though he drove right by Mr. McDuffie, that he never saw him. He never saw him when he drove by him, he never saw him when he turned, he never saw him at any time. So there's an inference, at least a jury question there, as to whether he looked at his mirror whatsoever. He has a duty to operate, remember, he's operating a 70,000-pound dump truck. So he has a duty that's different than a normal motorist who has to abide by these regulations and by these statutory rules. It's even more important for him because that's why there's federal regulations that govern under the Federal Motor Carrier Safety Act and the regulations therefrom that govern commercial vehicles, because we recognize, and the federal government recognizes, these are dangerous, people can die. You get hit by a truck, it's a lot worse than if you get hit by somebody in their Toyota Prius, generally speaking. So there's a heightened duty, a heightened standard for both the driver and for the defendant company. And so they failed to maintain their equipment, they failed to maintain the brakes, they failed to follow the federal motor safety regulations, and then we have the spoliation of evidence, which got lost in the sauce with the majority opinion. There was a lot. I'd like to just go over the timeline on the spoliation, because this is another factor that goes into the totality here that should allow a jury to decide this case. So on March 18th, 2021, I sent requests to produce 4 documents that I knew they were required to keep under federal law, not just common law, federal law, such as the vehicle maintenance files, because they argued below, and they argued at the Court of Appeals, that the vehicle was perfectly maintained and that all these experts, including the Michigan State Police, are just wrong. I asked for pre-trip inspection reports, driver qualification files, applications for employment. They never produced anything. And so I had to go to a deposition of the defendant owner on April 19th, over a month later after these were due. And I took his deposition and I asked him, where are all these items that you're required to keep so I can give them to our experts in this case before your attorney files a motion to dismiss and says I haven't proven the case. He says I threw them all in a dumpster. He says I closed my business up, I threw them all in the dumpster. That's not an excuse for throwing away federally mandated items that you keep. This wasn't voluminous. He could have put them in a backpack or a briefcase and stuffed them in his closet at his house. I don't care. But he had to keep these documents. There's no excuse under the law, there's no authority that says because you have a failed business, you can throw away federally obligated documents that you're required to keep. So 4 days later, defendant files answers to the request to produce that they had previously not provided, and they just filed blanket objections. So I filed a motion to compel before the trial court, a motion for spoliation. The trial court did not rule at that time. They gave the defendant, they ended up giving them 60 plus days. They said, you get at least 30 days. She ended up giving them 60 days to come up with either the documents or a reasonable excuse as to why they hadn't come up with the documents. They were not able to do so. Over 60 days later, the court held a second hearing where at that point she fashioned the remedy in this case to try to balance the equities and not allow them to benefit from the destruction of evidence, but she could have given a default and she didn't. She said, I'm going to not allow them to argue that the truck was in good repair and condition when they destroyed documents they were allowed to keep. I would remind this court it's an abuse of discretion standard. You may say to yourself, I would have done something differently if I was sitting there in the trial court's position. But the law, and it's not just in Michigan, but if you look at the law federally and across other jurisdictions, they place the power for these spoliation decisions with the trial court. And the reason that they do is because the trial court knows the parties, they know the history of the case, they know the nuances, they know what's going on in the nitty-gritty, and the law gives them the power to fashion a reasonable sanction.
Would you agree, though, that the trial court who has that authority has to make a finding of whether or not the evidence was material? And the Court of Appeals said that she didn't do that here, and then proceeded, I get your point, to say, in any event, this wasn't material, and it's not material because it wouldn't have made the question of whether or not the truck was at fault for the accident. So it's a little bit circular with your C10 argument, right? That there is a question of a genuine issue of material fact about whether or not the truck is responsible for the accident. But so the trial court did need to find materiality. And then, I mean, your argument is that the Court of Appeals just got the materiality point wrong on the spoliation?
Yes.
For the same reason why it should have gone back under C10?
There was never a genuine question on materiality at the trial court because we all had argued that the turn signal was a major part of the problem here. They argued that the turn signal worked perfectly without any mechanical or expert basis, by the way. That the turn signal worked correctly. We showed through 3 different experts and a Michigan State inspector that it didn't. So I never saw materiality as being seriously in dispute. When you have them saying it was working, us and a neutral Michigan State police officer saying it wasn't, I don't see how materiality could really be at issue here. Maybe on the truck itself, because as the Court of Appeals dissent pointed out, well, you didn't need the truck if you had these other things. Okay, but the trial court was in a position to look at these issues, and they should be. And I think this is a great opportunity to issue an opinion. There hasn't been an opinion on spoliation from this court in a long time. We have Brenner versus Kolk, which was the seminal case from the Court of Appeals, but this is happening more and more, and we're having it in a lot of cases where evidence is being lost.
You have a minute and 20 left, if you want to reserve.
And so with that, I'll take my cue, and I'll save the rest for rebuttal.
Good morning.
Morning.
Please the court, John Schutza, appearing on behalf of the defendant Appellee NSS Construction. The Court of Appeals got the breach of duty issue right, in my opinion, and in the opinions of Judge Godola and the other member of the majority. Judge Borello, thank you, Justice. They were correct, the majority, when they said, look, the testimony of Trooper Wilson was that he inspected the truck and the turn signal after the accident, and I think they even put it in italics that it was after the accident, and it wasn't working. But there was no evidence, and then we had an eyewitness who was right behind the dump truck who said unequivocally the turn signal was blinking or flashing. The problem is, although Trooper Wilson testified, quote, under my training it would be that these lights were not working prior to the crash, he never expounds on it. He may be the greatest accident reconstruction or truck inspecting expert around, but just as this court and the Court of Appeals has ruled repeatedly that in the face of a motion for summary disposition, you're not going to withstand that motion if you come forward only with a conclusory affidavit stating a conclusory opinion. The case should be the same as to this testimony.
What should he have said in addition to that?
Well,
Because you have a witness who says it was blinking, and we're taking that conclusory statement. Or a jury, I mean, you may be correct that a jury may find Mr. Pace more persuasive than a trooper who says, based on my experience and my review of this, it wasn't working. What more was he supposed to say?
Excuse me, Justice, like any expert, give us a foundation. Tell us how you got there. You know, what could have been done in this case, and it inexplicably never happened. When we filed our motion for summary disposition, and in the motion pointed out this problem with his opinion, could have had an affidavit from Trooper Wilson explaining how he got to the opinion, and maybe that would have created a question of fact. But based on his testimony at his deposition, there was no substantively admissible evidence to refute the eyewitness testimony that this turn signal wasn't working.
Are you conceding he's an expert and then just attacking the foundation of that opinion, or are you taking the position that whatever testimony he offers after there's been an accident is not reflective of what the state of the turn signal was before the accident?
Well, I think both. I think I touched on this in the
So you're accepting that he is an expert?
Excuse me, Justice?
You're conceding he's an expert?
Well, for viewing the evidence in the light most favorable to plaintiff for purposes of summary disposition, but we don't know because, again, there was no foundation laid.
But obviously the trial court found there was enough. So I'm struggling with, we're at C10, we know breach goes to the jury. And did the Court of Appeals step in and substitute for the trial court on fact finding?
Well, no, I don't think they did that. What they said was, we don't have, a genuine issue of material fact was never created by the evidence that's in this record that we're looking at with a fresh set of eyes. Although, you know, even if there was deemed to be a factual dispute on the turn signal issue, although I don't think the Court of Appeals expressly spoke to it, I think it's fair to say it was not a material factual dispute. Because, again, there's no evidence in this record that even if a turn signal had been displayed, that A, the decedent would have seen it, or B, that the decedent would have reacted and said, oh my gosh, I'm going to give up my effort to illegally pass this dump truck by driving on his right in the parking lane. We know there's all kinds of tragic accidents that safety measures don't prohibit. People routinely going around railroad crossing to try to beat a train across the tracks. It's speculation to say that a flashing turn signal would have stopped this driver from trying to get around our dump truck. Also, I think I touched on it in the supplemental briefing. I don't want to spend a lot of time on it, but there's this principle that where you have eyewitness testimony. If a person is an expert, he can't denigrate the eyewitness testimony of somebody who saw the actual event. There's no evidence Mr. Pace had a dog in this fight, that he had reason to make up a story about a flashing turn signal. And so, I think the case was Badalamenti versus William and Beaumont Hospital in the Court of Appeals years ago, that stands for the principle that an expert simply cannot choose to disregard what an eyewitness testifies he or she saw. Then also, the Court of Appeals said a very important thing in their opinion, I think it was at page 15, the facts indicate that while turning right from the appropriate lane, the dump truck was struck by the Sebring traveling in the parking lane contrary to law. Cases going back 75 years in this court stand for the proposition that a driver has no duty to anticipate that another driver is going to pull some illegal maneuver. More recently, in the El Jamali versus Kirko Manic construction case, a decision out of this court last year, this court held that a defendant does not have a duty to prevent injuries that occur because of unforeseeable conduct. And what the decedent did in this case was legally unforeseeable conduct, driving illegally in the parking lane, trying to pass this dump truck on the right. The decedent.
To just be clear, the Court of Appeals didn't make a finding that there wasn't enough foundation to discount the expert. Is that correct? I think they just didn't address it, did they?
They did not make a finding, what, I'm sorry?
On the expert where you said there wasn't enough foundation for his statement.
I would say that implicitly they did when they said there is no evidence.
I know, but they just didn't even mention it.
They mentioned the trooper's testimony, and I think it's a fair reading of the majority opinion that they didn't put any stock in it because there was simply no explanation for the opinion, no basis for the opinion other than my training and experience. This court has on many occasions also upheld the Court of Appeals if they reach the right result for the wrong reason. And, I think this notion that a defendant does not have a duty to prevent injuries that occur because of unforeseeable conduct is just as valid a reason as any for upholding the majority in this case and denying leave to appeal. The other theories that were pled, as the Court of Appeals noted, there's a laundry list of things we allegedly did wrong. We didn't have good functioning brakes, should have had different training, et cetera, et cetera. There's no indication, no evidence in the record that even if that, first of all, there's no evidence that any of those alleged violations played a role in this accident, in this tragic accident. My remaining time, I would like to touch on the spoliation issue. Counsel is indeed very correct. There hasn't been a lot in recent years from this court on spoliation, so in our briefing, both in response to the application and the supplemental brief, we looked at some decisions out of other jurisdictions, other courts, and one of the things that is repeatedly stressed is that the plaintiff has the burden to establish the materiality of the evidence at issue. That was not done in this case, and the trial court never made a finding of materiality. The trial court was never presented with any extrinsic evidence by plaintiff indicating that the discarded records or the dump truck itself would have shown some defective condition in the truck or lack of maintenance or repair. We offered the truck. We found it. One of my colleagues actually found the truck on the East Coast, and we had the location. They could have gone and inspected it. For whatever reason, they chose not to. The other big point on spoliation that was not satisfied in this case was there has to be some evidence that it was reasonably foreseeable to NSS Construction that they were going to get sued over this incident. One of the biggest indicators that it was not reasonably foreseeable and that this litigation was not probable, it's not enough if it was possible, it was not probable. Nobody ever requested of NSS, please preserve records, please preserve the truck. Nothing. And in fact, that was remarkable because we know that the personal representative actually went out and took pictures of the truck before suit was filed. But there was never any request to NSS Trucking, please preserve this evidence. There was no criminal charges brought against our driver. He was not civilly found at fault for the accident. There was no reason other than, as the Court of Appeals said, the tragic nature of the accident, there was no reason to believe that they were going to get charged.
Was NSS aware that the representative went and took pictures of it?
No. There's no evidence as far as that goes.
So
it was in the impound lot, I believe at the time that the personal
that
representative.
information came to light afterward?
Right. Just briefly, they were very disproportionate sanctions as well, and I'll rely on my briefing as far as that goes, but there was no evidence of any culpable intent by NSS Trucking to deprive plaintiff of evidence to support her claims in this case. And in fact, the court's August 4th, 2021 order regarding spoliation doesn't contain any express finding that NSS engaged in destruction of documents or other evidence in an intentional effort to subvert this case. We would ask that the court deny leave and send this case back to the trial court so we can get our sanction money back. Thank you. Any questions?
Thank you.
I'd like to point out, it's not just Trooper Wilson that found that this taillight was not functional prior to the crash. It was our accident reconstructionist and expert as well, Larry Berriman. On page 29 of his deposition and in his report, he performed a thorough analysis. His credentials were never challenged. There was no Daubert that was anywhere near successful. I don't even think they Dauberted him at all. He explained his rationale. So it's beyond dispute. The court has to accept unchallenged expert testimony in that regard. They rely on this Matthew Pace guy who, if you watch the video closely, could have been investigated for potential manslaughter because it looks like he sped up to not let Mr. McDuffie merge into the lane. If you look closely, there's a gap. As Mr. McDuffie begins, he speeds his vehicle up. By the way, this guy crashed during his deposition. I told him stay off. I said, he did it on his cell phone. I said, you cannot be driving while you're doing this. He crashed his vehicle during the deposition. He is not a credible person, which is why it's up to a jury in this case. He also gave inconsistent statements. He said there was a tree, then he said there was no tree. Then he said, I didn't see the brake lights. So there's inconsistencies that are up to a jury in this matter. I would finally ask for Justice Clement going back to duty. I would ask this court to take a look at Presnell. I cited it in my brief, Presnell. It's a federal case, but it's almost identical here. In that case, there was a motorcyclist trying to pass a truck on the right side. The truck turned into the motorcyclist. The federal court said a reasonable juror could conclude that the driver failed to adjust the angle of the fender mirror, number one, failed to look in the mirror, number two, had he done those things, he would have noticed the motorcycle. In addition, he failed to perform a pre-trip inspection, exact same thing here. And finally, the court said, quote, "Without a properly functioning turn signal, plaintiff would not have had any warning prior to passing the trailer that the driver was about to turn right." It's on all squares. It's a federal case. I think it's instructive because it goes through some of the breaches and the duty. And I'm happy to answer any questions that you may have. Thank you so much.
Thank you. The case will be submitted, and we will stand at recess until 1 p.m.